We're ready to go. Yep. All right, colleagues, we're live now. Good afternoon. This is the Hearings and Economic Matters Committee. It is January the 25th, 1 p.m. We are now starting our hearings. As you well know, well, I guess the order we're going in, we have Delegate Bagnall with House Bill 251 is going first. Then second is Delegate Rogers, House Bill 78. Third, Delegate Stewart, House Bill 258. Fourth, Delegate Crosby with House Bill 145. So we have, and before we get started, please, everybody listening and everybody on, the chat is only for members. Obviously, keep yourself muted until it's your time to testify. The members themselves, of course, do not have a time limit. Everybody else, we're going to be assigning 2 minutes to speak. I want to make sure we have the clock up and running. Okay, outstanding. Just want to make sure I saw it there. All right, so we can get going now to Delegate Bagnall. Are you, let me see that. There she is. You can go ahead and start. You can go ahead and start.
Good afternoon, Chair, Vice Chair, and members of the committee. For the record, I'm Delegate Heather Bagnall, District 33 in Anne Arundel County, here on behalf of HB 257, Residential Elevators Inspections. You have my written testimony, so I will try to summarize. Since 1981, according to the Consumer Product Safety Commission, 22 people have died in residential elevator accidents, with the most fatalities being children. Additionally, according to a study in clinical pediatrics from 1990 to 2004, over 29,000 children have been seriously injured. Although elevators in Maryland must be registered with the Commission of Labor and Industry and are subject to annual inspections and more extensive examinations every 5 years, currently elevators in private residential homes are exempt from registration and inspections. House Bill 257 stipulates that residential elevators shall be included under this existing law that already applies to commercial elevators. Each such elevator must be inspected upon installation or change in ownership by an elevator inspection company that is registered with the state, maintains a minimum $150,000 elevator inspection general liability insurance policy, and did not install the elevator being inspected. You will see in my written testimony an explanation in greater depth of the existing dangers and injuries, but the main catalyst for these injuries is the ability of children, given their small size, to be caught in between the door and the elevator carriage. Maryland law already accounts for this hazard for commercial elevators. However, it is estimated that since home elevators are not included in current law, around 300 to even 500,000 residential elevators nationally, and around 10,000 elevators in the state are not inspected. In 2021, the Consumer Product Safety Commission filed a lawsuit against one home elevator company that had been involved in 3 separate accidents, one of which resulted in death and another in permanent disability. And recently, CPSC has instituted the first ever safety recall for residential elevators, but only extends to a small ratio of existing residential elevators. When a similar bill was brought forth in the Senate in 2020, there were significant concerns regarding backlog, which have been addressed in HB 257, which requires inspections be carried out by a third party rather than the department, and the costs be paid by the homeowner. House Bill 257 is a reasonable response to a very real public safety issue, preventing the debilitating injury and death of children and adults by bringing residential elevators up to code with Maryland law that already applies to our commercial elevators in the state. For these reasons, I respectfully request a favorable report on HB 257.
Apologize, colleagues. First on the panel is Don Winkle.
Right. Yes.
There he is.
Yes, I apologize. I'm traveling, but considering the gravity of the issue, I believe that the committee needed to hear. My name is Don Winkle. I am a member of the ASME Private Residence Committee for over 20 years, including the Limited Use Limited Application Elevator Committee. These are the ASME committees that create the code with regards to private residence elevators. In 2016, and then again in 2019, the code was updated to address the issue with regards to children being trapped in the elevators. Numerous task meetings were held with regards to reducing the space, and anthropometric data was used to create a safe area where the children could not be injured with regards to it. But then again, with regards to speaking with codes don't do any good, and they're not worth the paper they're written on if they're not enforced. The non-enforcement of the private residence issue with regards to the private residence is a direct result of the injuries that you're seeing now. Numerous homes, while we understand that homes are the person's castle, or that numerous homes are being rented to others with elevators in them, and the families that live in these homes don't understand the gravity of the issue. That's why we need to pass 257 in order to protect the most vulnerable people in our population. There are numerous home residence laws that are enforced with regards to something in your home. Something as important and as complicated as an elevator in your home needs to be regulated by the state. Thank you.
Thank you, sir. Next, we have Frank Boston.
Yeah, good afternoon, Mr. Chairman, members of the committee. I'm Frank Boston III, and I represent the Elevator Industry Work Preservation Fund. And you will hear from my member mechanics who are experts in this field, and they'll give better testimony in this regard because they do the work every day. I want to thank the sponsor, Delegate Bagnell, for putting this bill in. Believe it or not, this is not our bill, but great minds think alike. We were going to introduce the exact same bill. And when we saw Senator Young and Delegate Bagnell had the bill in, we just jumped on board instead of being duplicative. This is a safety issue, as the good delegate mentioned, and we believe it should be addressed. These residential elevators are not being inspected, and it's something that, should be addressed. And the bill calls for it to be inspected at under new construction, newly built elevators, or at turnover at the sale. I'd like to point the committee to the fiscal note. The fiscal note, first year, the expenditures to the state are only $38,000, and after 5 years, it only increases to $67,000. And that is simply for the administrative costs, administrative work of approving the permits, et cetera, that goes. And they feel that they will need another employee at the Department of Labor. The bill says that there's about 10,000, the fiscal note says there's about 10,000 elevators in circulation, increasing residentially around 450 a year. So this really needs to be addressed. And with that, Mr. Chair, the members of the committee, we ask for a favorable. Thank you.
Are there any questions, Mr. Boston? Mr. Boston, I do have a question. Because again, we're talking about residential elevators. What would the cost of this inspection be, and who would bear that cost?
The owner of the elevator, which in the bill would be the seller, bears the cost at this time, and the person therefore selling the house or someone who's building a new house obviously would pay the cost, not the buyer. The cost of the inspection, will vary, and I will defer to the people who are testifying later to give you a more precise answer regarding how much.
Okay.
I think it varies because, one elevator can take a little bit longer. It's based on, it's not necessarily a set fee. It's based on hourly work. So it depends on how long the inspection takes and what work needs to be done.
And I'll say, obviously, I put a bill similar in, years ago for
Yes,
non-residential. So, but I do think it would be concerning to find out what the actual cost the individual would have to bear for this I think we only have one other individual that's going to testify on this bill. So hopefully that individual is the expert that you're talking about. But before we go on, I do have Delegate Arentz.
Mr. Chair, I can wait till the next testify.
Thank you, sir. Mr. Howard, can you also wait? Delegate Howard, can you wait, or would you like to go now?
No, I can wait, certainly.
Thank you guys very much. All right, we have one more person to testify, and that is Mr. Timothy Marshall.
Mr. Chair, I think we signed up. I don't know what happened. It should be a John O'Connor from outside. Is he not on your list?
No, sir.
Okay.
Is he on?
Yes. Kong, are you there?
I am.
Yeah.
Okay, well, I can still call him, so we'll make an exception.
Thank you. But
So next individual we have is Mr. Timothy Marshall. Mr. Marshall, are you here? Mr. Marshall, I see him. I believe he's muted. He's raising up his cell phone. Can we unmute him?
Am
There
I
you go.
muted now?
You're good now.
All right.
Go ahead,
great,
sir.
good. All right. Good afternoon, Mr. Chairman, Mr. Vice Chairman, members of the Economic Matters Committee. Thank you for the opportunity to speak to you about House Bill 257, residential elevator inspections. Kids are being killed by residential elevators, and our state has done nothing to prevent it. The big issue is the elevator installers does not normally supply the hoistway doors because they typically match other doors in the home. These doors are not designed to meet the elevator code. I recently was selected to be an expert witness for a case down in North Carolina. I saw firsthand how easily this loss of life could have been prevented. Just like Maryland, North Carolina does not have any type of residential elevator inspection. The elevator in North Carolina was installed in 2003 and then sold to the current owner in 2013. The maximum clearance allowed between the accordion gate and the hoistway door is 5 inches per code. It was installed with a clearance that measured more than 8 inches. This child was 7 years old. The elevator moved in the up direction with the young boy hiding in the elevator threshold. His father acted heroically and tried to free his child, but to no avail. The lifeless body of the child was dropped into his father's arms as the firefighters were able to lower the elevator down. During our investigation, I vacuumed pieces of bloody glass from the elevator sill so we could check the operation and verify all of the interlocks and gate switches working properly. Everything was operational, but the illegal gap killed this child. This accident was preventable. I am in favor of House Bill 257 with the following amendment. I would like to remove the exemption for units installed prior to 2023 and have any dangerous gap made safer by placing either space guards or electronic monitor devices that would deactivate the elevator when a child is detected in the gap. Qualified elevator inspectors can examine these elevators, and if there is a dangerous gap, report to the owners, and then they will fix it from there. House Bill 257 will prevent these senseless accidents, primarily affecting children, by bringing residence elevators up to the code with Maryland law and also supplies to our commercial elevators in the state. I respectfully request a favorable report on House Bill 257.
Thank you, sir. Delegate Arntz, do you want to go now or would you like to wait?
We have more to go? More
We have
tests?
one other, I'm letting John O'Connell testify. I think that was another expert, so maybe we'll give you guys a little more.
I'll wait one more, guys. That's fine. Thank you.
Mr. Howard, I ask you to wait one more time. Mr. O'Connell, are you there?
Yes, my name is John O'Connor. Good afternoon, Chairman Wilson and members of the House and Economic Matters Committee. I'm the business manager for IUEC Local 10. I represent more than 1,400 elevator mechanics and apprentices in Maryland, Virginia, and Washington, D.C. area. I've been an elevator constructor for over 26 years. I've worked in all areas of the elevator industry, including construction, maintenance, modernization, repair, and testing. I'm here to speak on the favor of House Bill 257. Elevators and escalators are part of a great industry that requires comprehensive training and education for the workers. Regular and routine maintenance on the equipment, strong elevator safety laws and regulations, and safety inspections performed by licensed mechanics and witnessed by qualified inspectors. Private residence elevators are part of this great industry. However, they do not receive the same regulatory attention as commercial elevators do. But I can assure you that the accidents and injuries on private residence elevators are just as real and just as serious, as we all saw in Potomac, Maryland last August when a young boy was injured in a fall down an elevator shaft. And the deaths are just as gruesome as we saw in Corolla, North Carolina last July when a 7-year-old Weston Andrew was crushed to death by an elevator and home that his family had rented for a summer vacation. I can also assure you that if the private residence elevator inspection standards contained in House Bill 257 had been in place in Maryland and North Carolina last summer, the Potomac boy would have never been injured and Weston Andrew would have never been killed. Most, if not all, private resident elevators owners in the state of Maryland do not even realize that the space between the elevator doors, also known as the door gap, is large enough to fit a child or a small person. I say this to drive home the point, not to be gruesome, but when it comes to the door gap clearance issues, a person can only fit into the gap once. When you get caught in that space, there are no second chances and no do-overs. You'll be crushed and you could even die. House Bill 257 calls for inspections on newly installed private resident elevators, as well as inspections on existing private residence elevators on each change of ownership of the home. 257 also requires space guards to be installed on private resident elevators when, when the space between the elevator doors is large enough to fit a small child. Space guards are inexpensive and they save lives. Some of the last work I did out in the field as a mechanic was installing space guards on private residence elevators all over the state of Maryland. Georgia, Massachusetts, Minnesota, Missouri, Kentucky, Nevada, New Jersey, Albuquerque, New Mexico, which has 80% of all elevators in the state. They push this. Washington, D.C. and West Virginia inspect private resident elevators.
I need you to wrap it up, sir. I really appreciate it, but if you could bring it to a close,
Okay. I'm a resident in Maryland, and I would love to. I'm in full favor of this bill.
thank you very much. I know we have some questions. Delegate Arentz, you've been waiting very patiently and baldly, so I'd ask that you go first.
And baldly, thank you, Mr. Chairman. Thank you guys for being here. I got about 3 pieces of questions here. You all mentioned the issue that I've heard most about was this gap that's been there. And the first guy that mentioned it, I think Mr. Marshall, that the elevator was not properly installed. That's why the gap was there. And it sounds to me like when you install these things, that gap should be set. And I'm unclear as to how that gap changes. Can somebody help me with that?
Yeah, so the gap doesn't change. You're completely right. So if you measure it's just a standard door, it's normally about 3 inches from the edge of the hoistway door to the edge of the wall. And that's just a typical door. The code has always required it to be no more than 5 inches from the door to the accordion gate, the inside area of the gate. But the problem is the people that are paying for the elevator, contractors, they want the elevator put in, then they put their doors on, and then the elevator gets passed without the inspectors looking at it. So it's just been a systemic issue for years.
Okay, so that's probably an install issue. The next question I have is on the real estate. I think Frank, Mr. Boston mentioned that you all would like to have this inspected and paid for by when a home is transferred. Currently, a real estate contract allows for this. It doesn't specifically state an elevator, but it does allow for any inspection. And I've had 2 homes with elevators in them. And each time I had my elevator inspected, but it was my choice. So the opportunity to have it inspected is already there for somebody. And elevators are not as commonplace. And I would think that would be something if I was buying a home as an agent, I would recommend somebody get it inspected. So I'm a little bit vague on that one. And the other point would be that when I had my elevator, it was stated on my insurance company, and I'm a little concerned that the insurance companies aren't aware of this and they're not actually identifying this as something that we have to have extra coverage for or requiring that. I have to put a security alarm in my home to get my discount. I would expect that if elevator, that would be more on the insurance company line. Is that so?
I think-
Elevators are not registered with any governing body, so the insurance company would not necessarily know there's an elevator installed.
But when I buy my home, and I understand they might not be registered with the insurance company, but when I bought my home, and this is like I say, when I bought my home, I had to file it under that. So this would be a new install that you're saying that a new install, that if the gap was not set. I'm just a little vague on making people pay for something when they should be looking at it overall. On a real estate agent, I make that stuff very aware. So it's a little bit vague for me. And as far as rentals, when a couple instances you mentioned was a rental where somebody got hurt, how will you manage that? I mean, every time the house is rented or the place is rented, do they have to go through an inspection? You don't have to answer everything, Tim. I'm sorry.
No, the bill, this is
Oh.
Frank Boston. The bill doesn't speak to the change of rentals, it's change of ownership.
Okay, but it mentioned with some of these actions were rentals and stuff. How are you going to police a rental? If I have a rented home, I don't have to do this if I owned it for 20 years with an elevator in it?
So Delegate, it's a good question. And in a perfect world, we would love to put in a bill that would that would have called for an annual 5-year inspection, kind of consistent with, build other buildings and commercial. But to be quite honest with you, we didn't think that bill would pass this year. And the reason is we are still phasing in the commercial and public buildings, the other public and private buildings that are non-residential. And we felt that maybe it's best to get those phased in, start with, at turnover with these buildings and new construction. But yes, we absolutely do believe that at a minimum of every 5 years, all residential elevators should be inspected, but we didn't put that bill in this year.
Okay, thank you, Mr. Boston. Thank you, appreciate it. Thank you, Mr. Chair.
Thank you. Delegate Howard?
Thank you, Mr. Chair. So it's my understanding under the bill, Steve kind of took my question. It says under each change of the residence. So under each new renter, there would be another elevator inspection. Rental agreements are typically a year, so yearly inspection.
Mm-hmm.
What I'm concerned about is that I just quickly Googled the length of time and the amount of elevators in Maryland in our own state buildings and commercial buildings that are going uninspected due to shortage of workers and some previous legislation that was put in place. So how do we get around that? I mean, now you're talking about 400 or 500 residential elevators a year on top of the gap that we have in the state, in our state and commercial buildings alone that are, these inspections are expired.
Right. And so I'll speak to the first question first. Good questions, Delegate Howard. The bill doesn't speak to rentals. And so if someone's renewing a lease every year, that building, that residence is not going to get inspected. It's only at the change of ownership of the buildings, meaning the sale of the building. So, annual rentals, this does not apply to. Maybe it should, but it does not apply to. And we didn't make it that way because we realized the cost on all of the parties involved. Regarding your question about a shortage of inspectors, this, that, and the other, and an increasing number of more residential elevators coming online, it's getting done now. Could it be better? Could there be more people in the industry? Absolutely. But it is getting done. It is slow. And that's why we didn't want to put in that it should be at, an annual test or the 5-year test right now, because you're right. It's an industry that is growing. It's an industry that is needed. But this is, a perfect opportunity for a lot of the elevator mechanics who retire to get involved. But you do raise a good point.
Well, my concern is that, this would be contingent on the rental or sale of someone's home. We can't inspect our own buildings, elevator wise. So, you have to understand my concern that there would not be a transfer of property of real and private property based on this inspection. We have a huge shortage right now. So I have some real concerns about that.
Yeah.
Well, Seth, I know this is your subcommittee. I believe we will be sending this bill to subcommittee. I do believe we'll be able to work through some of these issues and discuss them further. I do know you have quite a few issues. I would be curious. I saw the fiscal note, and I noticed that it would cost $29,000 a year for a single employee, which begs the question on the level of employee we'd be hiring for roughly $15 an hour as a state employee for this important. So I know there's things that can be worked through in research in the subcommittee. I do know this will be going to subcommittee. So if there are any other questions, guys, please, keep them, write them down, communicate with the chair and vice chair of the subcommittee.
Thank you, Mr. Chair.
Delegate Bagnall, before we hop off, you look like you had something else to say.
I just wanted to clarify, the fiscal note is not the cost of the inspector. The inspector would be a third party inspector. Yeah, that's the
It's an administrative assistant.
Administrative
It's
assistant.
just seems like a very low salary for a low estimate for even administrative assistant since Target pays more. Any other questions? All right, we'll go on to the next one. Thank you, Delegate Bagnall.
Yep,
Thank you.
Thank you.
All right, next we have Delegate Rogers, discrimination, employment, reasonable accommodations for applicants with disabilities.
Good afternoon, Chair Wilson, Vice Chair Crosby, and colleagues of the Economic Matters Committee. Delegate Mike Rogers, representing Legislative District 32 for the record. I respectfully request a favorable report for House Bill 78. This will ensure that job applicants with disabilities have reasonable accommodations during the interview process, allowing these applicants to fully demonstrate their qualifications. While Americans with Disabilities Act technically requires the accommodations in the hiring process, too many Marylanders find that they are not provided with these accommodations during hiring. Codifying this right in Maryland law will ensure that Marylanders have a chance to demonstrate their qualifications. HB 78 requires employers to take reasonable accommodations for applicants with disabilities, including allowing alternatives to an online application process, such as hard copy applications, accepting video resumes, or other alternative formats, allowing a third party or direct support professional to provide assistance during an interview, and providing an interview location that is accessible for individuals with mobility impairments. While HB 78 explicitly lists reasonable accommodations for disabled applicants during the interview process, it does not limit the employer to list or require all of the accommodations to be met. The bill does not require employers to adapt the accommodations listed in the bill if doing so will cause the employer undue hardship. As a nation and in Maryland, we have an untapped segment of working adults with disabilities who are neither in the workforce nor looking for work. Enabling and supporting people with disabilities to enter and stay in the labor market is an important, and I would argue, an imperative to growing and sustaining our GDP and strengthening our economy. This proposed bill will strengthen the current laws and create reasonable accommodations during the application process. The Maryland Commission on Civil Rights has offered a friendly amendment, which I have asked for. I respectfully request a favorable report for HB 78.
Thank you. Any questions for the good delegate? Seeing none, first individual we have testifying in favor of this bill is Glendora Hughes.
Good afternoon, Mr. Chair, Vice Chair, members of the committee. Glendora Hughes, General Counsel for the Maryland Commission on Civil Rights. We're the agency that would be enforcing this law. We enforce the employment discrimination law for the state of Maryland. We support House Bill 78. It provides clarity as it applies to applicants for jobs. One of the things that a person with a disability may request, it's not automatic, they may request a right, a reasonable accommodation. And it's something that the commission has accepted complaints based on our case law and based on our disability regulations. This puts it in the statute and codifies it. We did respectfully ask for a modification, an amendment, friendly amendment to the writing of this bill, where it requires a qualified applicant. And our concern was that placing qualification in front of applicant is a barrier where persons who don't have a disability don't have to be a qualified applicant, and that it would require the qualification process to take place before the person even gets an opportunity to apply and even be able to ask for the accommodation. So for the purpose of clarity and not creating another barrier, we may ask the friendly amendments that we submitted in our testimony to correct that, so that we can provide an opportunity for all Marylanders with disabilities to be able to have the same advantage of applying for employment as anyone else. And for these reasons, the Maryland Commission on Civil Rights respectfully asks for a favorable vote on this House Bill 78. Thank you.
Are there any questions for the witness? Seeing none. The next witness to testify in favor is Christopher Dews.
That's me. Good afternoon, everybody. My name is Christopher Dews, and I'm a policy advocate for the Job Opportunities Task Force, where our mission is to help low-wage workers advance to higher wage jobs. I want to just echo everything that's already been said by the delegate, the bill sponsor. I think that this piece of legislation for us is just a matter of expanding opportunities for a population that still has an incredibly high unemployment rate. As of right now, we're only at 45%, according to disabilitystatistics.org. So we just see this as a method of enhancing opportunities for those who are experiencing disabilities, specifically when they have the competency to do the work, but not necessarily, may have some issues with regards to applying for the position. So nothing else really to say there. I think the other witnesses have spoken to it very strongly, so we will leave it at that. Thank you all for listening.
Any questions for the witness? Seeing none. The next witness in favor is Andy Culp.
Yes, hi, thank you, Mr. Chair and members of the committee. I'm Andy Culp, testifying for the Maryland Developmental Disabilities Coalition. And the coalition is comprised of 5 statewide organizations, including the ARC Maryland, who I'm from, People on the Go of Maryland, Maryland Association of Community Services, and the Maryland DD Council and Disability Rights Maryland, all committed to improving the opportunities and outcomes for Marylanders with intellectual and developmental disabilities. And as such, the DD Coalition supports House Bill 78, and you have our written testimony, so I'll summarize. While Maryland's above average compared to national data and the number of people it supports in integrated employment, there's been little growth in the past decade. And according to the Bureau of Labor Statistics in the 4th quarter of 2019, 19.2% of workers with a disability were employed compared to 66.6% of workers without a disability. And this legislation is important because adequate accommodations and supports are essential to the employment success of many individuals with disabilities and can lead to full participation in community life. So this legislation will put in statute that employers should make reasonable accommodations, including in the interview process. And when I directly supported people with disabilities in the community, what we saw frequently was people unable to access the computerized timed applications at places like Home Depot and other common retailers. So it would allow them to get a paper application in those circumstances. And another accommodation could be allowing people to have support personnel or others to provide assistance during the interview and working process. So in short, we support this as a coalition, and I'm open to any questions from the committee. Thank you.
Are there any questions from the committee? Any questions on this bill? Okay, we're on the House Bill we're on the 3rd bill today. I believe it's Delegate Vaughn Stewart. Is Mr. Vaughn Stewart here?
Hi, sorry. Delegate Stewart is currently testifying in ENT and says he will try and come over as soon as possible.
That's fine. We'll just get back to him as soon as we're done. We have a little bit of a longer bill with Delegate Crosby. We have
Okay,
10
thank you.
witnesses here with Delegate Crosby. House Bill 145, prevailing wage and stop orders. Delegate Crosby, are you here?
I'm here, Mr. Chair. Thank you. Good afternoon, and distinguished members of the committee. For the record, Brian Crosby, and it is my honor to present House Bill 145 entitled State Finance and Procurement Prevailing Wage Stop Work Orders. This bill would require that any private contractor or subcontractor that works with the state of Maryland pays a fair wage to their employees and gives the Department of Labor's Commissioner of Labor and Industry the power to issue a stop work order if it is found that the contractor or subcontractor is not paying the prevailing wage. In 1965, the U.S. Congress passed the McNamara-O'Hara Service Contract Act, requiring the government to use its bargaining power to ensure that any private contractor that the federal government hires to pay fair wages for its workers. The contractor is required to pay the prevailing wage in the locality as determined by the U.S. Department of Labor, or the rates contained in the predecessor's contractor's collective bargaining agreement. This is the prevailing wage. Similar to the legislation, this legislation is similar to what was passed in New Jersey. This bill will ensure that any contractor that conducts business in the state of Maryland pays their workers the prevailing wage of the locality where the work is performed from the outset. For these reasons, I ask for a favorable report on House Bill 145.
Are there any questions for the good delegate? All right, first individual we have lined up to testify today in favor is Mr. William Yole.
Hello, respected delegates. I first want to thank you for your time and the opportunity to speak before you today regarding my association's support of House Bill 145, the stop work orders. I am the director of the Maryland chapter of the National Electrical Contractors Association, or NECA for short, and I have the pleasure of representing over 170 electrical contractors who employ over 7,000 Maryland residents. NECA contractors are high road employers that provide the highest wages, a family health care plan, second to none, and two means of retirement, an annuity and a pension, so that when the time comes for a worker to retire, they can do so comfortably and with dignity. In fact, the prevailing wage that is set across the state mirrors our wage and fringe package because NECA contractors pay our employees the highest total compensation relative to any other electrical contractors throughout the state. The reason why NECA supports the passing of House Bill 145 is because it protects the hardworking men and women of Maryland from unscrupulous employers that mean to steal their wages to help them win bids they otherwise couldn't, or even worse, to steal their employees' wages and outright line their own pockets. For any contractor awarded a state-funded project, they must be held to the highest ethical standards alongside the expectation of quality craftsmanship, both fundamental reasons why the state of Maryland has imposed a prevailing wage. If a contractor wins a bid by not honoring the prevailing wage, they have unfairly been awarded a project at the expense of the honest contractor who did follow the rules, the taxpayers by cutting corners, and the employee by worker misclassification and outright theft of wages. By putting a stop work order at every site where a violation occurs, the unethical contractor will have to endure the consequences of paying the appropriate fines, making their employees whole for any lost wages, and have the company's reputation tarnished, and also be removed from a job outright. To protect a public works project from untimely delays due to the stop work order against a subcontractor, the prime contractor may terminate the subcontractor without inquiring any liability for damages. And this allows the prime contractor to award that part of the project to a new subcontractor so that work can continue with limited interruption. For these low road contractors that exploit their employees and steal their wages, there needs to be a means by which the contractor is held accountable. And it is our belief that House Bill 145 will do just that. And that is why Maryland NECA supports the bill and hopes you do the same. Thank you.
Outstanding with your time management, sir. So we have one question. Delegate Walker.
Thank you. Maybe this is for the sponsor of the bill or the desk gentleman that just spoke. So right now, I mean, under current law, they're not allowed to do this, right? But there are cases where we're seeing people get around prevailing wage, and if so, what's the current penalty for that?
Is this directed at me, sir?
Whoever the sponsor thinks should address it. Maybe I should ask sponsor or it could be
Crosby.
Delegate Walker, I think what we should probably have do is let Roger Mano brief first, and then we can talk through him as well as some of the other guys that are a little bit more familiar with the topic.
Yeah, well, Jay, we'll come back around. We just, because there are some complex issues here, like you said, with the specificity, which you're asking. I know former Senator Mano, he'll be able to answer those questions. So we'll come back. If you could just hold off on that question. Thank you, guys. Thank you, Jay. Next person we have testifying in favor is Troy Singleton.
Chairman, thank you for this opportunity and the members of this committee. My name is Senator Troy Singleton. I represent the 7th Legislative District in New Jersey Senate. And as a prime sponsor of this legislation, now law in New Jersey, it's an honor to speak to my colleagues here in Maryland. I'm also a member of the Eastern Atlantic Regional States Council of Carpenters. So I come to you not only as perspective as a policymaker, but someone who's seen firsthand what happens when workers are exploited by unscrupulous employers. I'm in strong support of this legislation. As you can tell, I want to thank Vice Chair Crosby for his sponsorship and leadership on this, because I think it is important that we move not just for what we did in New Jersey, but also see it happen here in Maryland. This bill will provide the tools necessary for the Commissioner of Labor and Industry in Maryland to protect workers and hold bad employers accountable. In New Jersey, we've seen instances where employers do not keep payroll records, misclassify workers as independent contractors, and not provide the proper workers' compensation insurance to employees who qualify. These practices must stop, quite honestly, and the most effective way is to give the commissioner the ability to issue stop work orders when the employer is in violation. Employee misclassification is a problem because when workers are misclassified as independent contractors by their employers, it not only diminishes their access to labor protections, but also has real consequences on the state's economy and tax revenues. We acted on this in New Jersey after the New Jersey Department of Labor audit found that more than 12,300 cases of workers being misclassified, which resulted in more than 460 million in underreported wages and 14 million in lost state unemployment and temporary disability contributions. That audit conducted was only on 1% of businesses, which gives us an example that this is a more widespread problem than anyone can imagine. Before all else, we must protect the rights of men and women who are working hard each and every day to earn a decent and fair living. We cannot build a stronger and fairer economy without a strong workplace protections that ensures fairness for employees. New Jersey has set a standard for that, and I'm confident my colleagues in Maryland will do the same. I urge your consideration and support for this legislation. Thank you, Chairman.
Are there any questions for the good senator? Okay, next we have testifying in favor, Tierra Smalls.
You can just go with T, Chairman.
T.
My name
Did I
is
butcher your name, brother?
No, you did, but I'm used to it. It's been happening all my life. You know, it's not a big deal.
Could you give me the pronunciation just for edification?
Ngichi is Terea.
Wow.
In English is Terea.
Okay, I wasn't gonna get that.
Don't ask me where it came from either. But you know, in an effort to not be redundant, a lot of the things that already been said. Well, let me roll it back just a second. I'm the business manager and financial secretary and treasurer for Plumbers and Gas Fitters, local number 5 here in Washington, D.C. I took over just over a year ago, and I've been in organizing efforts with our local, and I've been involved in our apprenticeship program for a long time. And I don't want to repeat a lot of things that a lot of gentlemen said earlier, but this is a huge, huge problem. I represent over 1,800 members, over 300 apprentices, and over 3,000 members that participate in our benefits plan and things like that. We pump a lot of money into our apprenticeship program, our training program, and all of that type stuff. And this is a problem. Our contractors run into it, the community runs into it, and individuals are just being exploited and used. Let's call it what it is. Contractors know the rules, they know the regulations, there is no enforcement, nothing's happening. And we're dealing with it all the time. And, you know, I'm just not one for mincing words. And this is a sore spot for me. So that's why I'm supporting this House Bill 145. I won't drag this out. I know there are some questions, and I'm eager to answer those questions in detail to this House bill.
Are there any questions so far, colleagues? So then I have a question just for the edification of the committee. We've been hearing about misclassification. Could you explain what misclassification is?
So on jobs, you know, on Maryland state jobs, prevailing wage, you should have an apprenticeship license, a registered apprenticeship license. You should have a plumbing license in regards to my field. Okay.
In most cases, this doesn't happen. You have a certified master in the case that pulls the contract for that job, and they pass it off to a private entity that in turn runs that project that carries none of those credentials. So the responsible party is not on site for the project. Therefore, you have folks that are not skilled, not trained, and installing the work, and not only that, being paid out of the back pocket or paid under wages by means of check or whatever.
And we're talking about the subcontractor that was hired by the prime to do a specific part of a portion of a job, correct?
Correct. And, just to speak clearly about it, I mean, we found these cases to where there were all types of workarounds in different counties in the state to prevailing wage projects, to where we're finding this with our lead organizer through the Mid-Atlantic Pipe Trades.
So that would also include a painter who basically sweeps up after he's done with his painting.
Any and every trade that should carry a certification and falls under prevailing wage. Yes, to answer your question.
Okay. I do see two other questions. Delegate Walker.
Thank you, Mr. Chair. That was kind of similar to what I was trying to figure out. You say these cases are appearing.
Yes.
Now, for most, like, let's suppose, I know down in my district, there was a joint partnership, right? It was a union and a private partnership kind of working together on a big project.
Mm-hmm.
So if somebody, if this bill were to pass, and let's suppose, the private portion of it, which may be 20% of the contract, whatever, if they're hiring their own people to do it, then how do you prove whether or not they were part of the, the 80% or the 60% of the agreement that was arranged between the public and the private?
Honestly, this is all being done through enforcement. There's certified payroll, there's site visits, all these involved to make sure that the percentages are broken down properly and the pay is divvied out accordingly. Does that answer your question, or are you looking for something else?
No, I mean, I can understand the pay and the enforcement. I guess I just would be worried a little bit if you're talking about stopping a project because of some type of enforcement, which could get between the weeds. We want some schools built. We wanted a big casino built down here in my district,
right?
On a timeline.
Right.
I just wondered, could this jeopardize that project with the enforcement? It's like almost going to court. If I got to prove, hey, I did this, they say, they tie you up in court, legislatively, legally, there's a time frame associated with that.
Well, there's a stop work orders always have a time impact. They always have a time impact, especially, but that's the importance of making sure I's are dotted and T's are crossed on the front end, and enforcement throughout the project is in place. If there's no enforcement throughout the course of the project, it's going to happen.
I guess I get you. I'm trying to get it, but what kind of scares me, I'm not construction, but when I hear the word stop work order, I'm thinking you're going to stop right now. You're going to bring that project to a halt until this is clarified. Am I right with that?
You're absolutely correct. And I'll tell you, in my experience.
Let me go back one second, Small. So if that's the case, and like Mr. Chairman said, if we're talking about somebody that was painting or, just painting a room, or he said sweeping up, I was going to say removing some garbage, whatever, everything comes to a halt because of something like that.
So to clear this up and give you some field insight, because I know you said you're not in construction. I've worked in the field and I've ran projects and done a lot of county projects. Most stop work orders do not happen on the spot like that. You're given an opportunity to self-correct that situation within a matter of hours, 24 hours, 48 hours, whatever okay? That's typically what happens. It's not hey, you don't have the right broom or you don't have the right whatever, shut it down right now.
Thank you, Jay. And I want to say that Delegate Walker, because I know we have more questions, and I believe we have a former Senator Manner will be able to answer for some of our more complex legal questions specific to this bill, not the intent, but the actual specificity. So I just want to thank you, sir. Delegate Brooks.
Thank you, Mr. Chair. Perhaps this question should have been posed to Senator Singleton, but Mr. Smalls, I'll give you a shot. He was talking about misclassification of workers,
Yes.
And I know under common law, I think there are about maybe 15 categories that has to be met so far as IRS is concerned, determining who's an employee versus who's an independent contractor. So do you guys use common law to determine? I mean, it seemed like it would be kind of difficult for someone to misclassify someone if you going by common law rules.
Well, you're exactly right. There's a lot that can get really messy. Okay, and as far as classification in my trade, I can speak specifically for plumbing. It's an apprentice, journey worker, or a helper. I mean, that's simply, and we have classifications within that, and most of those classifications are identified with the state prevailing wage.
All right, thanks. Thanks, Mr. Chair.
Thank you. Delegate Rogers.
Hey, Mr. Chair, this is just a point of personal privilege. I just want to acknowledge T and the great training program that they have down there at Local 5. I've had the opportunity to visit it on a couple occasions. So really thank you for the great program that you guys have down there. Thank you, Mr. Chair.
Thank you. And Delegate Brooks, do you still have a question? Okay. Mr. Smalls, thank you for all the answers you provided and for the expertise you've laid out and the questions you dealt with. Really appreciate your time, sir.
I appreciate you.
Next, we have testifying in favor, Mr. Kunta Bedney.
Yes, good afternoon, Chairman Wilson, Vice Chair Crosby, committee members, and guests. My name is Kunta Bedney. I'm a council representative with the Eastern Atlantic State Regional Council of Carpenters. I service the DMV area, DC, PG County, Charles County, Montgomery County, and Northern Virginia. I'm here in support of the prevailing wage stop work order bill. I would like to start by sharing my life story and why this bill is so important to people like me. I had a rough childhood growing up. My mom served 10 years in prison. My dad was killed in Lawton Prison in Lawton, Virginia. My great aunt raised me and she did her best to keep me out of trouble, but trouble found me. I dropped out of high school in 11th grade and started running the streets. I was arrested and had 18 months to think about my life. When I came home, I went to a pre-apprenticeship program that allowed me to earn a GED and a pre-apprenticeship certificate in construction. I enrolled in the Carpenter's Apprenticeship Program, worked my way up from an apprentice to a journeyman, then a foreman, and now I'm a council representative. It is important that these programs continue to thrive in low-income areas and continue to help people that need second chances to change their lives from poverty to the middle class. I am proud to say today that I am a father of 6, engaged to be married, and a productive citizen, all of which I learned from professional men and women in the Carpenters Union. This bill stops unscrupulous contractors from being bad actors in the construction industry. If contractors aren't breaking the law, they have nothing to worry about. This legislation ensures that workers like me are paid their wages and benefits to which we are entitled and have earned under the law. Thank you for your time, and I ask for a favorable committee report.
Sir, thank you very much for sharing your life story. Wonderful to hear your success and the way you fought out of that hole. It's very inspiring for all of us here. Thank you very much for coming to testify and sharing your voice with us today. Taking no questions for the gentleman. Next, we have Lanique Estimi.
Yes, that's Lunique Estime.
Thank you, sir. You can begin. Sir, if you can hear me, you're on mute.
Oh, okay. Yes, there you go. Is that a little better?
All right, we'll start the clock and go. There you go.
Okay. Yes, my name is Dr. Lunique Estime. I'm a certified MBE in the state of Maryland. We're located in Lanham, Maryland. As an MBE, I'm also a signatory contractor with the Carpenters Local Union, and we hire quite a few union contractors because of the reliability and quality of the work done by these workers. In the competitive bidding field with high-stakes projects, it's nearly impossible to compete with contractors that underpay their workers by not complying with the law. In addition, it's also dangerous and simply not the right thing to do to hardworking men and women. Beyond that, from a pure business point of view, the stakes are just simply too high for us to engage in such unethical tactics. I have a lot invested in my company. We started in 1996, and our reputation means a lot to us. So getting involved with underpaying our workers is not something we want to do. And To be honest, it actually puts us at a disadvantage when other contractors do not play by the rules. As a contractor, we've hired numerous men and women to handle both large and small scale contracts for us, and they always do a very good job for us. And that's why we always continue to go back to the local union. To give you a sense of scale of the projects we hire, we've just completed some work at the Capital Region Medical Center. We've worked at Fort Belvoir for the military contractors, and quite a few projects for the military as well as the state of Maryland. And throughout that, we've never had the need to underpay our employees. So we do not feel the need for other contractors to do the same. As a proud MBE in the state of Maryland, we would like to thank you for your time and that we strongly support this bill. Thank you very much.
Thanks. Any questions?
Excuse me. Sorry.
Thank you very much, sir.
Thank you.
All right. Now we get to the incomparable Roger Mano, who clearly have questions to answer when he's done presenting. And Senator, you still only have 2 minutes to get your side out.
Thank you so much, Chair Wilson. And we'd like to thank Vice Chair Crosby for introducing this legislation. I'd also say to my good friend, Delegate Walker, 10-4. I know he knows what that means. And to all the members of the committee who took the time to meet with us and talk to us and answer our texts and emails. Thank you so much for doing that. I'm happy to answer any questions. And lastly, Mr. Chairman, thanks for that OJs and McFadden and Whitehead interlude. Appreciated that.
Roger, you're out again, bud. Can't hear you.
That was it. Thank you, Mr. Chairman. I'm happy to answer any questions.
Oh, okay. Delegate Walker.
Thanks. So speaking to my colleague as a former legislator, the position we're in, has the issue with this bill, why is like I was trying to ask Delegate Crosby, Mr. Vice Chair, outside of the wages of people getting paid their right that they deserve, I think we all agree with that. What seems to be the problem here, why this legislation is needed in terms of, what's going on? And are we overstepping?
Sure. Great question, Delegate Walker, and thank you. We're talking about taxpayer dollars here. So this is for folks maybe who are watching, we're talking specifically about state procurement, which are taxpayer dollars, and these are public works projects. There was a project in Montgomery County that comes to mind. I'm not going to mention the contractors, but it was a mess. What happened was it was a multi-level bus depot in downtown Silver Spring. And because of a lot of cutting of corners and things that shouldn't have happened, which happened, like pouring concrete for entire floors without putting any rebar in, this ended up in litigation. People could have been killed. The issue of public safety and the exigency that represents was not lost on anybody. And by the grace of God, nobody was hurt in that situation. But we hear this often. And it's usually, it's one thing when a worker is cheated out of wages, which is horrific. It's another thing when these are public work projects and when we as the state, or you as the state, expect a level of craftsmanship and training and certification from those workers, say, certified licensed electricians, and they bring in people who don't have that level of skill, it could be a public safety disaster. So this legislation is simply a tool in the toolbox of the commissioner. We don't believe that that the commissioner will use this tool often, but in cases where there has been an investigation and evidence collected, sort of a crime scene, in the extreme case, I think it's appropriate for the commissioner to have the option to shut down that work site when there's a threat of public safety, public health, and also to stop wage theft and theft of taxpayer dollars.
I'm with you on that. It seems, extra tool belt, I don't think anybody kind of argues about having that. My last question to you would be, if this bill had been in place, would what happened at the Silver Spring bus stop, bus depot, would this bill have prevented that? I don't know. I'm trying to see how it could.
If there was a state procurement of projects such as that, I think most certainly, as long as the evidence was collected and they knew or that had, they were either tipped off or they then went down to the work site and collected evidence. Yeah, I think you could have averted that completely. Yes.
Senator, I just have, I guess, because I was the way Delegate Walker asked this question. So you're saying that because this bill is not in effect, they could not have done an emergency stop order on a project that they investigated and found evidence that there was a true public safety. That they couldn't do that. Right now, they can't stop that. Right now, they cannot stop individuals who are pouring concrete on a project. They cannot stop an individual who's pouring concrete on floors without rebar currently.
That's correct. Under the current prevailing wage enforcement mechanism that the state has in place.
I apologize because I wasn't distinguishing the prevailing wage. I was discussing the public emergency that you were talking about with the Montgomery County project, that they had no means of stopping that, not with the prevailing wage, obviously, but through any safety bills or any inspection standards. There was no way to put a stop to that work, work.
So there may be through some law enforcement and regulatory mechanisms, but not through the Commissioner of Labor and Industry, who regulates prevailing wage in the state of Maryland.
Thank you.
Yes, sir.
Jay, do you have any more questions?
I'm good. Thank you.
Thank you. Chris, been waiting on you for a while, brother.
Yeah, thank you, Mr. Chairman. And I mean, of course, there's code, there's specifications, there's any series of ways for a project like that to get stopped before it reaches that point. But I guess my first question, Senator, is explain to me what an initial determination is. When the commissioner comes to an initial determination, what does that mean in your ears?
Delegate Adams, was that for me?
Yeah, absolutely. Sure.
Liberated from the state Senate, but thank you so much for that. I appreciate it. It's just Roger.
Sure.
So under this bill, the commissioner has the authority to gather evidence, and it's sort of like a crime scene, right? Or a probable cause determination. If the commissioner believes after gathering evidence and has made a determination that there's a credible case of wage theft, misclassification happening on that job site, the commissioner may, it's completely discretionary, issue a stop work order in order to straighten all of that out. After that, the bill lays out, I think, some very fair appeal process, as you can see in the bill and in the fiscal note. I think that's very reasonable. An issue did come up with the chairman at an earlier conversation about exigency. And I've also met with some of the folks who are supporting the bill with an amendment. The issue of exigency, I think, has been sort of misconstrued. The conversation that we initially had was, what if there were a work site where stopping the work worked an extraordinary public health risk, an issue of exigency. I can think of one off the top of my head. Let's say you're building Calvert 3 and you're installing nuclear fuel rods, and there is a credible claim of wage theft on that work site. The commissioner shutting down that work site may, inadvertently cause a threat to public safety, right? So that's one issue. I think what my good friend Sean Malone and Champ McCullough have offered would be a completely different idea of exigency. In that regard, and I'll let them speak to their amendment, it's a wholly different concept.
I don't know about the amendment. The reason why I was asking about what an initial determination is, to get to the point that that might be a finding from the commissioner, but it's not a point of fact that can't be challenged. Obviously, the contractor or the subcontractor can challenge that. And so to stop a project midstream while there's a dispute seems to be difficult at best. But, let me just follow through on that. There's an appeals board, but in the bill I'm reading here, a decision of the appeals board is final, subject to any judicial review. So let's say, you're imagining this appeals board being quick within 5 days and being done, but of course, that's not the right answer. What does it mean in the bill when it says subject to any judicial review? What if a contractor chooses to go down this judicial review process? What is that?
Well, it's laid out in the bill as well, Delegate. So there's a 3-day window for an appeal and to the Board of Contract Appeals. Thereafter, the Board of Contract Appeals has 7 days to issue an order ruling on that. If they don't, then that contractor can then go to an administrative law judge and ask the administrative law judge to have that stop work order lifted.
All right. Well, I mean, so I'm staying on this one and only point. I have other questions. We can save it for later. What I'm suggesting to you is that a stop work order to me means a massive and very significant stoppage of a project. It implies significant costs, not only to contractor or owner, but also to other trades that are working around other projects as you're going through goalposts and getting work done. And so if a commissioner comes to a determination that's wrong, and I would argue that prevailing wage bills aren't just, or laws aren't just, whether somebody got paid or didn't get paid. It can be maybe they were using a tool of the trade. And there's far more to these conversations than just a simple, hey, they violated it, move on. I'm suggesting to you that an aggrieved contractor or subcontractor, especially in a work order situation, would go to the mat and, irrespective of an appeals board, would seek any judicial relief that they could get. And you could be talking months, frankly. And so the bill, while I can certainly understand the intent, prevailing wage already has methods to deal with violations. They're clear and they're also significant. And this seems to severely, make more complex resolutions where I think at the end of the day, you're trying to deal with bad actors, and I get it. But this bill affects everyone. I mean, a stop order in a trade, say, for example, concrete. I mean, you're stopping the entire project for the one of a initial determination that's not fact. It is a determination, and it's not as if the commissioner doesn't get things wrong. But I have some doubts that this bill is workable on its face. But in listening to your answers, I don't get the sense that this has been well thought out as to what it looks like when there's like real conflict and two parties aren't coming together and you need a court to resolve it, which by the way, is still in the bill. The parties still get to go in a judicial review outside of an appeals. And in fact, I'd argue that quite often that's where this sort of thing leads.
But
thank you,
Delegate Adams, if I may.
Yes, sure.
I'm not a contractor, but I represent several hundred of them. And they support this legislation because they know just how important it is to make sure that they get this right. They don't want to end up debarred or, blacklisted from being able to bid on these projects, any more than anyone else does. And they have a vested interest in policing their own work sites and making sure that there's no illegal activity going on. But
Roger, since you said that, let me just follow up. So what happens if there's no violation found after the stop work order happened? And there's obviously under contract, you've got performance clauses. There's going to be liquidated damages. How do you make a contractor whole? You're telling me contractors support this. I find that hard to believe. But
Delegate Adams, if I may, only because I know that you're on this a wonderful asset to this subcommittee that this bill will be going to, that the work will be done in. So I want to make sure save some energy for that subcommittee. I appreciate what we're talking about here. We've been beating Roger up as he probably deserves from his time in the Senate, but I do believe we should.
For my days on ECM, Mr. Chairman.
But I like to keep it moving because there will be other discussions and we have a few more witnesses. Okay, bud?
Thank you, Mr. Chairman. Thank you, Delegate.
Thank you. All right, so thank you, Roger, for weathering that storm. Next we have is the incomparable Sean Malone.
Thank you, Mr. Chair and members of the committee. On behalf of the Associated Builders and Contractors, we actually support this bill. We do support it with amendments because many of the issues that have been raised we have the same concerns with. To Delegate Adams' point, what he's speaking about in essence is the due process that a contractor is afforded. Under the current prevailing wage statute, Delegate Walker, if a contractor is found in violation, they are subject to triple damages, they're subject to debarment, they're subject to attorney's fees. But that comes after due process has been found, an investigation is done, and a hearing on the merits is had. The way this bill is drafted, and we want to give the commissioner the tool to do this, by the way, but the way this bill is drafted, it creates a scenario where the investigation, in essence, acts as the final order. If a contractor is found culpable of a violation, or the investigation determines they violate prevailing wage law, a stop work order is issued. That means workers don't work, the company doesn't work, but it has a clause that that contractor can be fired. They're fired without ever being provided the opportunity to provide their side of the case and be replaced. Additionally, if they appeal, it goes to a new contract board, appeals board that doesn't hear these cases, as opposed to staying within an agency that has expertise over this. So what we have done is put forth a provision that would instead give the commissioner the ability to issue a show cause hearing in an expedited fashion if there's a safety issue. If there's not a safety issue, a little bit more time to be able to be heard before stop work order is put in place. The stage project stop, workers aren't paid, contractors aren't working, and people are terminated. With respect for the time, and I know we're going to go to work committee, I'll submit on our amendments, and I'm happy to answer any questions about the subject area.
Thank you, Mr. Balone. Any questions, colleagues? Seeing none. We have lastly on this, Mr. Chet McCullough.
Thank you, Mr. Chairman. Members of the committee, Champ McCulloch here on behalf of the Maryland Associated General Contractors, a trade association, as the name suggests, for general contractors. We have a simple amendment that I think will narrow the discussion to where all of the proponents and perhaps some of the opponents feel it should be. Our amendment would restrict the issuance of stop work orders to knowing violations. The prevailing wage job classification is complex, and it is not at all unusual on a work site for there to be instances where there's disagreement over what the correct prevailing wage that should be applied is in a particular job classification. I don't think that the ills that the proponents have laid out so thoroughly stem from those kinds of problems. It's not the accidental misclassification. It's not the bad computation. It's not the good faith disagreement over job classification. It's the knowing, deliberate, willful, and malicious contractor or subcontractor trying to get an unfair advantage, and in the process hurting workers and hurting all of the honest contractors. So all my amendment would do is to focus it on knowing violations. And I've borrowed the language from the State Finance and Procurement Article, Section 17-222, which itself recognizes that there is a difference between an innocent violation, which carries a certain level of penalty, and a knowing violation, which carries a significantly higher penalty. So I think you all have recognized this difference in the past. I encourage you to improve this bill by the adoption of that amendment, and I'll be happy to work with the work group. Thank you, Mr. Chairman.
Thank you, Mr. McCall. Are there any questions? Seeing none. All right, that concludes that hearing. We have one more to go. I hope that Mr. Juan Stewart is on the line.
I'm here.
Outstanding. We have today our final bill, Delegate Vaughn Stewart, to present House Bill 258.
Thank you, Mr. Chair, Mr. Vice Chair. I apologize for my tardiness earlier, but for the record, this is HB 258. So every day in our state, thousands of Marylanders clock in for their shift and stay on their feet for hours in a row. And for many of these workers, like nurses or waiters or construction workers, This predicament is completely unavoidable. Standing is an inherent part of their job. But this bill is about a different category of workers. There are thousands of other Marylanders who also clock in every day and also, save for maybe like a 15-minute break, remain standing for 8 hours or more, and yet they could perform their job not only as well, but better if their employer allowed them to sit down. This situation imperils workers' health, reduces workers' productivity, and makes life more difficult for both pregnant workers and workers with disabilities. And so HB 258 is pretty simple. It requires large businesses to provide a seat to an employee when an employee spends a substantial part of their workday performing tasks that can be reasonably done while seated. And if employers undergo a major renovation or construct a new facility, they can't design a workplace in a way that doesn't require standing for jobs that don't require standing, or they must design the workplace in that way. And for small businesses, their requirement is that they would have to provide suitable seating only if an employee requests a seat and only if there's no undue burden or hardship on the business. This concept is not radical. It's commonplace in much of the country and in the world. 7 states have passed this law, including not so progressive ones like Montana, Wisconsin, and Florida. Dozens of other countries have suitable seating laws. And interestingly, Maryland passed a criminal right to sit law for only female workers in 1896. But that law was repealed in 1951 alongside a bunch of other violations that lawmakers, our predecessors, didn't think should be criminalized. And in other states, basically, this is how it works. The law applies to workers who perform a task at one location for a significant period of time that they could do just as well while seating. So it doesn't apply, just to clear up any confusion, to workers whose task at a location would require them to sit down and then stand up and then sit down and then stand up. So think like a bartender or a cashier or a cashier who like regularly leaves their station to stock groceries. There's essentially 3 reasons why we need this bill. The inability to sit is bad for workers' health, it's bad for workers' productivity, and it's especially bad for disabled and pregnant workers. So first, no worker should be forced to needlessly sit. Studies have found that prolonged standing leads to serious health outcomes like lower back and leg pain, cardiovascular risk, discomfort, pregnancy complications. Secondly, studies have found that productivity decreases when workers are forced to stand throughout the workday. And that's why Aldi, which is a German grocery store, allows their cashiers to sit while ringing up customers. And Aldi actually is sort of famous for relentlessly tracking employees' ringing up speed. And it turns out that employees can scan your items faster from a seated position. And it's probably no coincidence that Aldi, with all this relentless tracking, is the fastest growing grocery store in the United States. And finally, the status quo is dangerous and unfair to pregnant workers and those with disabilities. While some of these workers are legally entitled to accommodations under the Americans with Disabilities Act, it's not nearly that simple. Many workers who need accommodations don't qualify for them. Many workers are afraid to ask for an accommodation, and many workers are legally denied accommodations. And additionally, many studies have found that employers avoid hiring people with disabilities because of the fear of accommodation requests. And this bill would take one such accommodation off the table. And finally, I've taken a look at the opposition testimony, and I think most of the opponents' concerns, I think, are a bit misplaced, but others, like those involving the enforcement mechanisms or exemptions for certain industries, or the time employers would have to respond to a complaint, I think are very reasonable, and I would be happy to address them with the sponsor amendment. So in the name of dignity, in the name of respect, in the name of productivity, and in the name of compassion for the disabled community, I urge a favorable report.
Thank you. Any questions for the sponsor? Okay. First,
yes, Mr. Chair, I do have a question.
Okay. Go ahead, Ben.
Okay, thanks, Mr. Chair. Yeah, a delegate. Now, I noticed that the penalty for a violation is $100 per week, and then any subsequent violation is $200 per week. Is that per, say, per location, or is that per employee?
It's per employee, and that's in line with how other states find this. I know that the opponents raised some concerns about the penalty provisions, about AG enforcement, about plaintiffs' attorneys, and private right of action. I'd be happy to tweak the enforcement provisions, and certainly if the committee's will was to lessen those penalties, I'd be fine with that.
Yeah, and oftentimes they say a happy employee is a more productive employee. And it seems like the employer would want those employees to be happy, and and if it would work out best for them too, for the season.
Yeah.
But I just don't. Okay. All right.
Yeah.
All right. Thanks, Mr. Chair.
Thank you.
Delegate Fisher, your hand is shockingly up, so go ahead.
Delegate Walker was first, but do you want me to go?
No, I think even he wanted to hear what you have to say.
There you go. That's a shocker. Delegate Stewart, how are you today?
I'm good. How are you?
Good, thank you. I have a question. You mentioned big employers. At what point does this bill kick in?
15 employees. Well, 15 employees.
So that would be considered a large employer?
Yeah, and that's consistent with how Maryland generally treats the distinction between large and small businesses. I believe that was the threshold for our $15 minimum wage bill as well.
And who are these companies to which you refer that are stripping people of their rights to sit down?
Well, first, Delegate Fisher, let me just say, I actually listened to the episode of your podcast where you generously highlighted the bill. And I think there is some confusion. I think you expressed some confusion about sort of what the implications of the bill would be. So I'm grateful that we're having this dialogue, first of all. But secondly, yeah, I think that in other states, what you see is that the retailers that most commonly have suitable seating laws required or apply to them are grocery stores. Namely, I think it's probably the prototypical example. If you have an employee who is going to be stationed at one place for say 5 hours at a time, and when research shows that they can actually be more productive while they're seated, there's really no reason why they shouldn't be given a seat.
And that's not currently in Maryland law, is that what you're saying?
That's correct. It's not. It used to be for female workers until 1951, and then in their infinite wisdom, our predecessors repealed that law because there were criminal penalties attached.
And what constitutes a chair?
That's another good question. So what courts and what other states have found is that basically anything applies. A stool would count, any sort of rudimentary chair you can get on for $5 on Amazon would count.
And so this would be the responsibility of the employer to provide chairs. So the department would then be responsible for enforcing this. So you're transferring this huge responsibility and power to the department to determine if people should have a chair in their workplace. Are you saying that people don't have breaks in the workplace? They don't have an opportunity to have a break or to have lunch in the break room?
That's a great question, and that's one you brought up on the podcast, and I'm grateful for the opportunity to clarify. So actually, under Maryland law, the breaks that are required under federal or state law are shockingly short. So if you have a typical shift at a grocery store that lasts less than, say, 8 hours, you're only entitled to a 15-minute break.
So you're only entitled to a 15-minute break, and what is that for? Just a regular break? You're not entitled to a lunch? Is that what you're saying?
I think that you can eat if you'd like, but the only requirement under Maryland law is if you have a shift of say 5, 6, 7 hours, you get 15 minutes mandated at a minimum.
Yeah,
do whatever you want.
I have never heard ever anyone complain. I certainly get plenty of complaints in my inbox from people, certainly over the period of time that I've been serving. And I've never heard anyone complain about the fact that they don't have the right to sit at the workplace. It doesn't seem like this is a problem. Help me out.
Well, I mean, I think that's wrong. That statement that you've never heard about it is probably wrong with one exception, because I actually looked at your YouTube comments for your podcast as well. And actually, I thought that one commenter named Anthony, and that you responded to, I actually thought made a great point here. And he said, quote unquote, when I sold DirecTV, I was actually forced to stand the entire shift. I did get 2 breaks during my shift, but getting to sit for 15 minutes during a 10-hour shift wasn't my idea of a good time. If there was a law to say that I was supposed to be given a stool or chair, they and I never heard of it. It is stupid that this bill has to be done. In every store I've ever been to, the cashier has to stand up. They could be seated, and they are overseas, but not here for whatever reason. As far as your hostess or waitress, those don't make sense as you have to move around too much. And I think so I mean, you have at least heard from one person with an issue. And I think that person who responded to the YouTube video is representative of thousands of Marylanders who have to stand needlessly. All these risks to their health are imposed upon them for no particular reason, to say nothing of the powerful written testimony that you've received about pregnant workers and workers with disabilities in particular.
Yeah, I mean, DirecTV, I'm confused. You mean he's putting satellite dishes on people's houses?
No, I believe he meant probably at the retail store, but you'll have to, he's your podcast listener, so you can follow up with him and let me know. I should have gotten him to come testify.
Yeah, I'm just saying I've never heard DirecTV having, I've got tons of retail in my district or throughout the region. I've never heard a retail person complain that they don't have the right to sit or have breaks at their work. I mean, it just sounds incredulous to me that an employer wouldn't let someone have a break. I've never heard of such a thing.
Me too, and me too. Yeah, I agree, and I think that's why the bill is so important, because we know this is happening. You'll see in your written testimony all the different labor unions that have signed on. We'll hear from more people about why this is such a significant problem, which is why other states have pursued this.
Well, I'm glad you brought that up, because aren't labor unions exempt from your bill?
They're not.
They're not exempt from your bill, because in Maryland law, they are exempt from this. Did you know that?
They're
so
exempt.
Your bill applies to private employers, but your bill does not apply to union shops, because in Maryland law, they are exempted. I'm literally
I see what you're saying
right now.
Well, union workers are certainly not exempted. And so, unions representing thousands of Marylanders who are forced to needlessly sit.
I just want to clarify, Delegate Stewart, that actually is not so. They are exempt under Maryland law, and yet they're coming here and testifying for something against private employers for which they are not themselves required to do, including under the bill that you have proposed.
Yeah, and I'll be honest, I'm not on ECM. That's an interesting point. I did not know that. If you want to put in a bill in the future to sort of change the definition of a business so that it includes how unions conduct their own in-office businesses, we can have that discussion, but that's not really here nor there.
Or maybe we should put in a memory foam amendment for your bill and get them from the My Pillow guy. Perhaps that would be a good way to go.
Yeah, well, that was the same joke you made on the podcast, which I thought was funny.
Still funny.
Yeah, no, it's still funny. I agree.
Okay, guys, I appreciate where this.
Thank you, Mr. Chairman.
But, thank you guys very much. Thank you, Delegate Fisher. Thank you for joining us today. Delegate Walker, do you still have a question?
Yeah, I do. Even to break the monotony of that last exchange. This bill, I'm kind of big on, are we searching for a problem that doesn't exist? And, then I'm always big on that. And it seemed like one thing that was interesting in your back and forth with Delegate Fisher was you said you hadn't heard of anything until somebody on his podcast brought up a situation.
Oh, no. I didn't mean it that way. I meant that it wasn't true that Delegate Fisher hadn't heard anything, because he had received a comment that he replied to. I've heard from plenty of my constituents. And in fact, my first job was actually as a grocery store employee. So I've experienced this firsthand down in actually Alabama.
Give me a job besides, I think we all agree with the cashier. Obviously that's stationary, but then you could also say the person that's working in the meat department at that same grocery store, they got to be pretty active, going back, even though they're listed as stationary. Where you're assigned to the deli, you're behind the counter. With this, and give me some more jobs. I need to hear some more jobs that this would be affected by.
Yeah, totally. Well, I think cashier is really the main one, because in other states and in other cases that have analyzed this, there aren't that many jobs other than cashier. Maybe a ticket counter person, at a movie theater, for example. That's kind of the same thing as a cashier. But basically anyone you can imagine in a retail store, for the most part, who have to remain at one workstation for a prolonged period of time are the kinds of employees that fall under these bills nationwide. And so while we, as Delegate Fisher actually mentioned, we delegate a lot of the authority to the department to decide which positions count and which ones don't, I can speculate a little bit on what they will say based on how other states have handled this. And a meat person, someone at the deli, would not apply, because even if they can cut the meat while seated, for example, they would obviously have to get up, at least in my experience in a grocery store, they'd have to get up and get other materials periodically. And what courts have said is that if you're in a job that requires you to be seated and then standing and then seated and then standing, that's not reasonably, that's not reasonable that you need a seat.
And then I worry about the slippery slope because I was thinking about other jobs this may be affecting. Believe it or not, I was thinking about some other jobs. So from you just explained a little bit. So somebody that works for a trash collector, they obviously, I was driving through this trash day in my neighborhood. They're on the back of a truck. They couldn't say, "Hey, I need a chair," even though
no, not at all. No, not at all. And I, you know, I don't want to go down the rabbit hole of a bunch of different hypotheticals because this is very well established
We
law.
got to a little bit. We got to go.
I don't. We have a lot of other witnesses. Please don't drag us down this rabbit hole, guys.
So
I'm not. Last one I'd ask is I'm thinking about this. The person that spins signs outside of the intersection. You know, they're kind of paid to do that. Does that become one where they can be required? The employer would have to say, "You got to give them a chair so he can spin the sign," even though that's what you're paying them to do to get everybody's attention.
No, I don't think that would be reasonable. And I don't think that if you go to any of these states like Montana, I don't think that you would see sign spinners sitting down. But I think that, you know, the important point here is twofold. Number one, there's well-established precedent laying out the jobs that this applies to. The states that have had this since 1900 have not gone down any sort of slippery slope to make this apply to weird positions. We would have heard about that when you guys take trips to California or Wisconsin or Florida or whatever. You would see that people are seated strangely. And number two, it's important to recognize that under this standard, typically businesses can use like their own business judgment or even customer service type considerations here. So the reasonableness in this standard is actually quite deferential to the employer, which is why in other states it really only applies to a very, very limited number of occupations. And then I'll conclude, Mr. Chairman, if you would, by just saying there was some opposition testimony requesting that we narrow it specifically and not give authority to the agency, but instead narrow it in the bill to exactly, you know, which industries. And I'm open to that. If it was in the committee's judgment to say this is not going to apply to mining or construction or trash trucks or sign spinners and just narrow it to what it should apply to and what it will apply to, which is retail positions, I'm fine with that.
Thank you. Thank you, Delegate Walker. Delegate Pippy.
I'll be very brief, Mr. Chairman. Thank you, sir.
Thank you.
This committee has actually regulated other areas, you know, tobacco use, things particularly impacting health. And one of the trends that I've noticed is that there are more people now standing. You know, they're encouraging people to stand all day because it's actually substantially better for your health than to sit all day. And they actually equate sitting with the very unhealthy. You know, we sit in front of the Zoom all day long and it's actually quite unhealthy. And so did you, and I missed the first part of this meeting because I was testifying on a bill, did you look into that aspect? I mean, it's one thing to regulate businesses, but are we trying to regulate something that's actually unhealthy?
That's a great question, actually. And I probably should have mentioned that initially. And actually, it's relevant. My wife is actually in the home office next to me using a standing desk. And you're totally right that a lot of interesting research has come out lately about the benefits of standing, but not prolonged standing. I think I cite to a couple of studies in my written testimony. You'll hear from an expert later on in the hearing to talk more about this. But essentially, the takeaway here is that prolonged sitting or prolonged standing are both bad for your health. And actually, a mix of sitting and standing throughout the workday is best. And so you remaining seated the entirety of a long ECM hearing is not a good idea for your health. But I would also invite anyone who doesn't think this is an issue to say, when you guys have a busy, 8-bill hearing next week, try to stand the entire time and see if you feel better or worse. It's not going to feel good. And so the key here, as with anything, is moderation. A little bit of sitting, a little bit of standing is both good for your health. And I actually also cite to a different study that it's good for productivity. If you do a mix of both, you're more productive and you're more healthy.
Thank you.
And thank you, Delegate Vaughn, for your economy of words. No, I appreciate you, again, taking all the questions. Obviously, I'm sure you're aware that when bills like this come out, they're sometimes shocking. So thank you for, dealing with the questions. We definitely have quite a few, 7 or 6, I think, favorables and few unfavorables. So if we could start with Jerry Graff. Is there a Jerry Graff? All right, we'll try and come back at the end. How about Bernard Martin?
Sir, I'm on.
Oh, Mr. Graff, there you go. Go ahead, sir.
Thank you. Thank you, Chairman Wilson, and honored members of the committee for allowing me to address you about Delegate Stewart's right to sit bill. I'm Jerry Graff, a Safeway full-time food clerk, front-end clerk for the last 31 years. 26 of those have been in the check stand. I'm also a UFCW Local 400 shop steward for the Rockville King Farm Safeway. I know that if I had a chair in my 4 by 2.5 square foot check stand, I probably wouldn't be suffering the way I am with as much pain as I have. I know of coworkers and friends who've left the job early because of what they've experienced in their cashiering positions. I have lived in Europe, and you even see it today in European-based stores, that the clerk cashier is in a chair, which to me represents the fact that they're more comfortable and, of course, less taxing on their health in the long term. Therefore, I please ask that you give favorable consideration to House Bill 258 and the right to sit. Thank you again. I'm sorry if you couldn't see me because I thought I had turned on the video as well.
No, sir, you did a great job. We could hear you and we could see you. Thank you for your testimony.
Thank you. God bless.
God bless you, sir. Seeing no questions, we'll go to the next person, Bernard Stewart. Oops, Bernard Martin, apologize.
Okay, I'm on. Good afternoon, Mr. Chairman, Delegate Stewart, and member of the committee and guest. I'm Bernard Martin, a professor in the Center for Ergonomics at the University of Michigan, and I'll be presenting scientific data in support of the right to sit law, and will address some of the concerns discussed a few minutes ago. So among several areas, my research concerns more particularly the understanding of sensory and motor system and the application of this knowledge to slips and falls, muscle fatigue, and rehabilitation. Hence, my interest is in the reduction of work-related musculoskeletal disorder, and in particular, musculoskeletal disorder, which are a significant burden to workers, businesses, and the economy in general. As you may have heard, NIOSH, the National Institute for Occupational Safety and Health, is trying to combat effectively this musculoskeletal disorder, and muscle fatigue is believed to be a precursor of musculoskeletal disorder. So in my presentation, I will indicate fatigue and probably skip muscle fatigue. So please understand it's always muscle fatigue. And also indicate that standing work means a full day of standing at work and having included rest that are usually the lunch and the rest break that are very short, usually in industry. So over a number of years, I've investigated the effect of static work condition and particularly standing work on long-lasting muscle fatigue and symptoms or disorder associated with standing work. This line of research, like mine and others, revealed a few important issues that I would like to highlight now. Lower leg muscle fatigue develop and persist more than an hour after the end of at least a 5-hour days of work standing. The seated rest break common in industry like 30 minutes lunch and 15 minutes in the morning and in the afternoon.
So I apologize, but we have a 2-minute limit here for those testifying. If you could wrap it up, I really appreciate the information, but we have to get on to other people testifying.
And so muscle fatigue is also accompanied by edema and vascular disorder. Standing work are associated with vascular disorder. So a number of symptoms and disease are associated with prolonged standing work. And I think that this law is at least a minimal step that is necessary in order to reduce musculoskeletal disorder. And to finally indicate that this similar law exists in Switzerland and has been validated by these studies.
Thank you very much for your time, sir. Seeing no questions, the next person is Kayla Mock.
Good afternoon, Chairman Wilson and members of the House.
Economic Committee. Thank you for your time and attention to this simple yet very impactful bill, HB 258, the right to sit. My name is Kayla Mock. I'm a political organizer with the United Food and Commercial Workers Union Local 400, and we represent about over 10,000 members in Maryland. Grocery, retail, food processing and distribution, law enforcement, healthcare. We have a hodgepodge of a little bit of everything. And, it's our members have been on the front lines of this ongoing pandemic and serving their communities as safely as they possibly can. But in regards to this bill, I think at its core is about humanity and decency for Marylanders, and it's about choice. In 2011, I was a part of a delegation of workers who went to the Netherlands, and I worked at Giant at the time. And we were visiting a sister store called Albert Heijn's, which is owned by the very same company as Giant. When we walked in, the store manager who was giving us the tour, me and my coworkers, we all gasped. And the store manager was a little put off, and he said, "What's going on?" And we went, "All the cashiers are sitting down." And he was very puzzled. And so we explained to him, that just doesn't happen here in the States. And he looked at us and said, "That is inhumane." And he's right. It's inhumane. There is no reason to deny someone the right to sit simply because the culture of the employer prefers that they stand. And that's what it is here. It's a cultural thing. Maryland deserves the dignity of caring for their bodies, and they deserve the choice of being able to sit down. We appreciate your time, and we urge a favorable report for HB 258.
Any questions? Thank you very much. Next, we have, I think that takes care of all the favorables. We have 2 unfavorables. We'll start with Kaylee Locklear.
Good afternoon, honorable members of the committee. For the record, my name is Kaylee Locklear, here on behalf of the Maryland Retailers Association, respectfully in opposition to this legislation. Businesses and our members work hard to accommodate their employees' needs. I also need to be clear that individuals who require seating due to a physical or medical disability may be granted a reasonable accommodation under the Americans with Disabilities Act. As Delegate Walker mentioned, most retail positions require employees to be on their feet or in motion in order to complete their tasks. This is made clear throughout the application, interview process, training, and employees are aware that they are being hired for a fast-paced environment where standing is a requirement. Even assignments that take place in one area of the store, we've talked a lot about operating a cash register, often requires an individual to move around in order to price check, to move to help with bags or return items to areas of the store. A seat in this existing small area presents an additional hazard to the front end, which is already where many retailers see the most liability and workers' comp cases. Many employers even provide no-slip comfort mats for those standing-oriented positions. We also believe the portion of the bill dictating to a business how you have to lay out floor configurations for future operations is an overreach, and asking the Attorney General to bring an action because of a chair is an inappropriate use of resources. Finally, the bill does not identify the period of time that an employer has to respond to a chair complaint if an issue presents. For example, if an employer is in the process of procuring seating and there is, a supply chain issue like we're having right now, the bill does not contemplate situations like this. So it's for these reasons that we are respectfully here in opposition to this bill. Thank you.
Kayla, I have a question. I think everybody here understands the good faith behind this bill and the delegates' intentions. And I obviously believe that a lot of it was targeted around, obviously, your industry, the retail industry. Are you telling me that it is more hazardous for a cashier to be seated than to be standing for 8 to 10 hours a day?
No, Mr. Chairman, I'm referencing the current configurations for cashiers. And so we talked a lot about, well, what does this chair look like? Even if it's some rolling stool, they could trip over that, or you could kick it out in front of another customer who's coming through another aisle. And that's the concern there.
They also have a trash can underneath their workplace, and they could also trip over that, though. It sounds like, and I go to stores all the time and shop, and if you look under them, there's a trash can. I just worry that because I understand his intent with the bill is to try to make it as comfortable as they can for individuals, specifically retailers. Almost, it sounds like they really are just talking about people working as cashiers. I would almost, it sounds like they're trying to narrow, they're not trying to narrow it down. And I don't understand, there are a lot of problems with the legislation, the way it may be drafted, but I just question the point about somehow it is a danger to have a chair when there are already plenty of other things around them. But we'll deal with that another time. I think since there are no other questions, we'll go to our last person today.
Mr. Chairman, I have a question.
There you go. Okay, Delegate Branch.
Yeah, who would this may be a question for the sponsor or someone of the likes, but who would have the responsibility of determining whether a chair is appropriate? I mean, the owner may say, well, we don't want you to sit the entire time or to sit, and your job may, if the owner is feeling that way and you feel that you should be sitting the entire time, what authority makes that decision of if that individual really should or needs to be sitting, other than them having some disability? What would determine that on in a legal setting?
Yeah,
I
thank you.
believe that question is for Mr. Vaughn. You want that for Delegate Vaughn?
He or Kayla, one of the two.
Yeah, sounds like more of a question for Delegate Vaughn.
Well, thank you, Delegate Branch. I appreciate that question. So it's a good one. Essentially, what the bill does is it gives a lot of authority to the Department of Labor to spell out exactly which industries and which positions this applies to. And I'm hopeful that, like in other states, that will provide the clarity that both employees and employers need to know when the bill applies. Now, that said, I'm sensitive to the opposition of concern about this being blurry or vague. I'm happy to entertain amendments or to even submit amendments to clarify who we're talking to. But to answer your question, the ultimate authority, if there was a disagreement, just like basically any other disagreement in the workplace, would fall to the courts. And so just like in the accommodations context for workers with disabilities, if they think they deserve accommodations, but the employer does not, they may have to go through some sort of administrative exhaustion requirement first, go to a state agency, but then ultimately the last line of defense is the court system. But based on the experience in other states, very, very few of these lawsuits have ever actually been filed or made it all the way through the court system. There are a few that give us clarity about, kind of how this should be enforced. But ultimately, I think that the department is capable of coming up with some regulations to make it very clear to all stakeholders who this bill applies to and who it doesn't apply to.
Is the department supporting this bill? Is the department, have they offered in any way, have they had input in saying that this is something that labor needs? Have they said that at all?
They've taken no position. I mean, I know that the state agencies very, very rarely take positions on legislation while they're pending, and this is no different. They have not offered any testimony either way.
Normally, it's pretty clear when you have a situation like this, who sits, who stands. I mean, normally they clarify that, opposed to, because you could have and I'm not an attorney, maybe the chairman would understand that you would be in court, in and out of court all the time, and determining who has a right to sit and who has a right to stand, and especially if the owner versus the employer is not clear on what's really appropriate. So, but anyway, I was just trying to understand the intent, understand what you're trying to do, but I was just concerned about that little piece.
Yeah, I appreciate that.
Thank you, Talmadge. We have one last person today, guys, and thanks for hanging on. Bob Benton. Well, maybe we don't have Bob in. So, colleagues, if there are no more questions, this was the last bill of the day. I thank you.
Chairman, I'm here. Mr. Chairman, I'm here. I had my mute and video off. Sorry. Robert Enton on behalf. Thank you, Mr. Chairman. Robert Enton on behalf of the Maryland Bankers Association and CVS. And I guess they have concerns about the bill. In all my years of representing both entities, CVS and the bankers, I've never had anybody ever bring a complaint regarding this issue, and I don't believe it's ever come up. It's never been highlighted as a problem ever before. There are so many retailers out there and employers. This bill applies to all employers. It has one set of standards for an employer that employs 15 or more employees, but it has another standard, and it applies to all employers. If you have one employee, it applies to you. That's going to make it apply to every liquor store, to every pet store, to every bank, to every, you name it, to every bar, to every restaurant in the entire state of Maryland is going to be subject to this bill. The bill then calls for, says you shall provide a suitable seat if the nature of the work that the employee performs can be reasonably performed when seated. So someone at the Maryland Department of Labor or someone in court is going to determine whether or not in each one of these cases that gets brought, whether or not it was reasonable, that was reasonably performed while seated. I can only tell you this, and the fines are substantial. The fining mechanism is very unclear, but in today's world, you don't drive past any shopping center, any business at all that doesn't have a sign out front that says we're hiring. In our current marketplace, in our current commercial setting, employees have a great deal more leverage than they've ever had before. We do think this bill is problematic, and we'd ask the committee to give it an unfavorable report. Thank you.
Thank you, Bob. All right, colleagues, that concludes our matters for today. I'll see everybody tomorrow on the House floor, and I'm sure we'll have announcements then. Pay attention to your emails. Take care.